ladies and gentlemen, you can't have gender equality by decree. And the encryption panel was all male with a female moderator. And I now have the honor of having a practically all girls set up with a male moderator. But so this is very interesting. Why do we have this? Why one panel not and one panel does? This is food for thought, and maybe this has to do with the history of encryption being very, very, very niche and very, 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 very boy game. And that might change in the future. So if there are passionados, females of encryption, please identify yourself, and next year we will correct that. But apart from the gender balance, the whole thing is about quality, and I think we have a high-level panel on the e-privacy directive. I was asked to moderate, and I will do this in a very minimalistic approach. The basic idea, and now I'm turning to the lawyers, is that the e-privacy directive is the next big thing. Now the reform package is over. So the e-privacy directive is this one singular text that had its purpose, that many of us knew from afar. But it is not an innocent one, or perhaps it is an innocent one. That's one of the questions this panel will have to address. Do we still need the e-privacy directive after the reform package? If yes, why? And should it be vitalized? Should it get new features? Should it address new challenges? So the chair of the panel will be done by Cornelia, who's sitting next to me, one of the oldest CPDP attendees. And Els, who was initially the moderator, Els de Busser, yeah? Yeah. Am I? Yes, I'm going to use first names. That's will add too much to say, and so then you disqualify as a moderator. And then so we made her, we turned her into a speaker, and so Rosa, Mikko, and Anna will then follow up. Bas van der Leij went to another panel. This is a very intriguing process of last-minute fine-tuning. I'm very proud of it, and I know you will like it too. So I pass the floor to you.
Yes. Thank you very much, Paul. So it's a pleasure to be here again. My name is Cornelia Kutterer. I'm working for Microsoft. I've pulled together this panel on the e-privacy reform, which is just now starting. I counted at least 3 very intense studies that have in the recent month been published on the e-privacy reform. And some of the key questions are, as Paul said, whether it is redundant or whether it should be kept, and whether it should be expanded, and how. So I will, with that, hand over to the panelists and quickly introduce them. So Rosa Barcelo from the European Commission will start with an introduction on the e-privacy directive. Rosa has been for the last couple of years in DG Connect working on the e-privacy directive. She is sort of the center of attention on the topic currently. She knows where we stand, what the thinking is within the Commission. She will then be followed by Mikko Niva, Head of Legal and Privacy at Vodafone, and obviously as a telecom operator already in scope of the directive and having a lot of thoughts around how that could be reformed. Then Anna, who used to work in DG Connect, is now at the European Data Protection Supervisor and will give their view on the forthcoming reform. And as we have specifically focused in this panel on one aspect, which is the confidentiality of communication, we have the pleasure to have Els de Busser here. She is an academic at the Max Planck Institute in Freiburg on criminal law, and she will be able to give us a little bit the other side of the coin and what that means actually for law enforcement. So I hand over to Rosa.
Okay. Okay, so good morning. Thank you, Cornelia. Thank you for the putting together this panel, which is very timely, and the invitation, and so thank you to all. I thought that we agreed that we would use my 5-10 minutes to introduce the timeline where we are about the review of the Privacy Directive. As Paul and Cornelia said, we have started this process of the review. The Commission had always been quite clear that the review of the Privacy Directive would start after the GDPR has been agreed, or if not yet formally agreed, at least there is political agreement. This had been said in the DSM communication, the Juncker letter to my commissioner telling him you should prepare the review and do it after the GDPR is adopted. If you think about it, it makes sense. It makes sense because the GDPR is the mother of the Privacy Directive, is a situation of lex specialis. So the Privacy Directive has to adjust to the GDPR. The two instruments have to work together well. So we couldn't start this review process until the GDPR was firm, solid, and we could look at it and then see how the two instruments can be work together. So where are we in this process? So we have, as I said, we have basically this month we have started. We envision doing the review work in 2016 and divided 2016 in two periods. A first period of 6 months where we will be on a listening mode. We will hope to get input from stakeholders about the review, all the aspects. And in order to make this easier, what we plan to do is in the first quarter to issue a public consultation, an online consultation with questions. Of course, people can also provide input outside the questions, but that would be our main input. In addition to that, we are a small team, and so we cannot spend a lot, but we hope to be able to do at least 2 workshops, one with the national authorities competent for the enforcement of the e-privacy. Remember, this is not always the DPAs. We have around 10 member states where the responsibility to enforce the e-privacy directive is given to the telco regulators, and whereas in the other member states is the DPA, so we would put together all the authorities. And then we hope to have at least one meeting with other stakeholders in addition to ad hoc meetings. That should bring us to close to June 2016, where we should have quite a lot of input, which we hope to put together in a paper summarizing our views and what we have learned or where we are. That should enable us in the second part of 2016 to advance further and prepare a potential new instrument. So, as I said, we have just started, and I cannot give any specific information about the content, but what I can do is just to tell you a little bit what are the main themes that we are looking at, the main broader topics. And I put them in 3 buckets. Probably there is more, but I think 3 buckets illustrate it somehow. So the first one is, and in some way I already mentioned it before, is adjustment to the GDPR. Now, when you look at the GDPR, and I must say I don't know it by heart, I don't know every bit and piece, but you see quite a few differences or areas that ring a bell. And this is the fact that it's a regulation. The e-privacy is a directive. The regulation will be applicable as it is. The e-privacy is now transposed in 28 laws. So the fact that there is these 2 pieces of law is it good? Will it be good that in the future we have these sort of differences of e-privacy, a directive, and GDPR regulation? Look at sanctions. For the GDPR sanctions, we have certain amounts that have been agreed that they will be applicable. E-privacy, member states have their own different sanctions. Look at the competent authorities. As I said before, GDPR is data protection. For e-privacy, is not always data protection authorities, are others. Is this good? GDPR, they have a consistency mechanism for cross-border. In the e-privacy that doesn't exist. So all these little aspects, each one needs to be assessed and see whether coexistence of these systems is good, is efficient, is appropriate, or a remedial action need to be taken and be fixed through a new instrument. So that, as you can see, is a lot of work, is a bucket. My second bucket is what we call refit. Refit means that in the Commission we have this sort of, I don't know how to call it program, but is the decision that some legislation goes through an efficiency for better regulation. We check the policy measure against criteria for better regulation to make sure that the rules are fit for purpose. So these criteria include efficiency, effectiveness, value added at EU level. So e-privacy has been selected as an instrument that has to be checked against these refit criteria. This means that there will be a lot of emphasis on making sure that each one of the articles is fit for purpose, is efficient, and it has a value added. Now, I could bring I think my colleagues might have some specificities I have seen in some position papers, but just I dare to put one as an example. If you look at I wouldn't say overlap, but maybe there is an overlap. Look at the personal data breach notification. When the e-privacy was adopted in 2009, there was no data breach personal notification in the data protection regulation, well, the directive. So the e-privacy was the first one. Now we have a situation where the GDPR sets forth general rules for personal data breach notification with criteria, trigger, etc. The e-privacy has another set of rules. So we find that those who are under the e-privacy have to fulfill the rules of the e-privacy on personal data breaches, whereas the others, the rest of data controller, go to the GDPR. Now, are there reasons that justify this duplication? As I said, we are not there to say, but I think we ought to look at whether there is a justification. It has to be analyzed and take the appropriate action. So this is my second bucket, and then the third one is the bucket of what we call a level playing field and a high protection for individuals. So level playing field for those who are not in the telco world it refers to the fact that telcos have been provided electronic communication services, access to internet, voice. Now, increasingly, we see other actors, sometimes called OTTs, software providers, application providers, that provide services that from a user perspective might be very similar to those provided by a telco. So I might decide to communicate with Cornelia with an SMS or with a WhatsApp message. And to some extent, there is a certain similarity that from a user might be sort of the same. So these OTTs are not covered by the Privacy Directive currently, or most of its rules, for example, confidentiality of communications. So there is a certain disparity that a service provided by a telco, by Belgacom, by Vodafone, has these rules that I would say higher protection, confidentiality of protection, whereas these OTTs don't have similar rules. So we need to look at this situation and see whether it has to be changed or is good as it is, or take the the necessary action. So these are my 3 buckets, and I think I would then leave it here and for Mikko to continue. Thank you.
Thanks, Rosa. That's I think it's excellent that the review is ongoing, and I think this will be very interesting spring. Tough timelines, I would say. Happy that at least the aspiration is not to have a similar process as what we had with the GDPR, which is still ongoing. But maybe some reflections and thoughts on where we are coming from when we look at this review. So maybe the first point to be made is that we see it as being part of the digital single market initiatives in the Europe. So similarly as with the GDPR, the e-privacy directive, as it will be reviewed, or the rules in it at least, will be very significant for the digital single market and the competitiveness in the European marketplace. But that's just the let's say the broader context. Some thoughts on the principles that guide our thinking on this very topic, more from a, let's say, material point of view. So we strongly believe that there needs to be certain digital rights that apply to all users of digital services, and privacy and confidentiality of communications clearly are among them. They are fundamental rights that apply to all communications and to all users of communication services, irrespective of the technology or the business model at hand. So the level of protection for the communications should not depend on the type of service, communication service that you are using. So we support the idea that the rules should not only apply to telcos, but to all providers of communications. And as we know today, this is not necessarily the case. At least that seems to be the winning interpretation. So we need to make sure that we review the rules, and we need to make sure that we review them in a way that makes them fit for the purpose of today's marketplace, of the communications landscape that looks to be ahead of us, and that is perhaps not as simple as it may seem on the first at the first look. So from our point of view, it's important to clarify that we are not saying that all the rules that apply to today apply to providers of electronic communication services should as such apply to the over-the-top players. I think we need to be a bit more creative and elaborate in our thinking than that. So there will be rules that need to apply at the network level. There will need to be rules that ensure the high quality of managed voice services, perhaps for those who use national numbering ranges and so forth. And there will need to be rules that apply to the services that are provided, kind of like relying on the network and the next layers in the services layer. So when we do the review, it's not a question of should we just repeal the e-privacy directive, should we take the existing rules and find a new home for them somewhere else. I think that is part of it, but clearly we need to look at the existing rules in very detailed manner and see what rules make sense and in what way they will make sense going forward. I think it's also important to notice that the protection of personal data and the protection of confidentiality of communications are overlapping, but they are not necessarily exactly the same. So that creates a challenge with the GDPR, for example, which is about protection of personal data. Whereas the confidentiality of communications seems to be a bit broader than just a question of human interaction. So we think the confidentiality of communications actually should currently covers and should continue to cover all types of communications, including machine-to-machine communications. It's kind of easy in a let's say Internet of Things environment to see why that is necessary. Someone just pointed to me that there's like a search engine that you can use to basically search for open ports in IoT machines and look, for example, sleeping babies and things like that. So perhaps that serves as a dramatic enough example for the importance to also protect the machine-to-machine communications against unwarranted intrusions. About the legal instrument, or perhaps the question is not so much about the legal instrument, it's about the harmonization, at least from our point of view. So we think that harmonization of the rules across Europe is really, really essential. And we think that we need to have proper consistency also in the interpretation of it. As we know, the GDPR has those measures, as Rosa also mentioned. And many of those services will actually, that will be regulated by both the GDPR and the future rules on confidentiality of communications will actually take place in context of one and same service. So it cannot be a situation where the interpretation starts to differentiate on that very same service on a national level, and then that we have different interpretations on a European level. So perhaps for us the most sensible way to address the instrument question is to basically review the e-privacy. It may be difficult in practical terms, but at least in principle it should be reviewed in context with the framework directive review. And if I still have a few more minutes to go, so perhaps some more detailed recommendations that we have. So confidential communications I already touched on. The cookie law, so-called cookie rules, is a pretty important piece as well. As we know, it doesn't only apply to cookies, it applies to all tracking software, which is something that is sometimes forgotten, also in the official documentation. And we think we need to look at them and see to what extent they continue to make sense. It's been a success in terms of raising awareness, but many argue that the user experience it has created is less than ideal, and it's a little bit restrictive. So first-party anonymous analytics of your services, for example, could be something that even the Article 29 Working Party has proposed to be included going forward. For traffic data, it's very important an element of confidentiality of communications. As you know, the metadata pretty much tells someone who observes that metadata a lot about that individual, to the point that someone said that you are what your metadata tells you are. So it's really an essential element. So and those probably need to be kept, those rules, one way or the other. But they need to be reviewed to make sure that they continue to make sense in a more and more connected world, and in a world where the communications is an element of a broader service. So some kind of analytics would need to continue to be possible. Well, say many kinds of analytics will need to continue to be possible. Unsolicited communications, I think that's quite nicely already handled, perhaps in the GDPR. So I'm not sure if those rules need to be kept. There are specific rules on itemized billing and caller ID. Those probably continue to be relevant to some extent, especially for, let's say, these high-quality managed voice and other similar services that are using national numbering ranges and so forth. So careful analysis is needed there. The security obligations probably need to cover all the confidentiality of communication, and yeah, so it's going to be a very nice, interesting challenge, and I really look forward to working together with the Commission to solve these issues. Sorry.
Moderating is done by technology. Anna, please, push play.
Yes. Thank you. Good morning, everyone. During my previous panel, I had the comfort of speaking as first, so I got to say what I wanted to say, and then the others had to worry about possible repetition. Now, speaking as third, I feel that a lot of what I noted as my points has been raised already, so I don't think that we are headed for a very controversial, panel of controversy and debate and disagreement. Anyway, as already mentioned, I had the pleasure of working on the previous review of the Privacy Directive back in 2008-2009, which brought us the cookies rules, among other things. I don't claim any credit for that. The credit goes fully to the European co-legislator, the Council and Parliament. Now I represent the EDPS, European Data Protection Supervisor. For those of you who do not know us, we are an independent authority that on the one hand supervises the way European institutions and bodies and agencies process personal data, and on the other hand we also advise the Commission and the other institutions on policy initiatives and legislative proposals whenever there is a data protection or privacy component. So in this case, we fully agree with the Commission and others who say that following the agreement on the GDPR and hopefully the formal adoption, which should take place soon, this is now the priority file also for us. What I can share with you today are some preliminary observations which are based on our early reflections, but of course this is also for us, like for the Commission, just the beginning of the road, so this is without prejudice to any official position of the EDPS which could be taken down the road. We also welcome the Commission's commitment to do a thorough assessment, including the refit studies and all the other preparatory work. We also welcome very much the clear link which is now being done to the GDPR. My personal impression is that the e-privacy directive has suffered over the years a little bit from sitting somewhat uncomfortably between the telecoms framework and the data protection directive. In very practical terms, also the timing of the subsequent revisions of this instrument never really fitted very well with what was going on in the data protection field. I think most recently some of us felt that the GDPR was perhaps a missed opportunity to actually incorporate many of the rules and make a really comprehensive data protection privacy framework fit for purpose for the future of electronic communications. But okay, that perhaps would have been in the ideal world. That did not happen. So now we have to work with the proposed review. Apart from the more consistency of application, consistency with the GDPR, also consistency of application. So we understand that we are speaking about a future regulation, no longer a future directive, but a regulation. For us, not surprisingly, the key is ensuring a high level of protection for individuals and maintaining the level of protection which they enjoy today. So we would certainly oppose calls to automatically almost remove certain provisions as overtaken by events or by technology. This means that I think in line with previous speakers, I would support that we focus on principles, not so much on instruments or any specific instrument, but let's see what are the principles at stake, what are the principles of protection, and also then reflect how best to achieve them in the new legal framework. It has already been mentioned here, but it is important to understand that whether we have e-privacy directive or a regulation or another instrument or not, there are certain principles. So we do have the Charter of Fundamental Rights with its Article 7, establishing the principle of confidentiality of communications. Even without the Charter, there is a more broadly applicable European Convention on Human Rights, Article 8, which sets essentially the same threshold, the same requirements. We think that it's important to have a reflection or interpretation of those principles in a secondary law instrument that would provide more legal certainty for operators, more clarity to individuals, how those higher level principles are actually transposed in operational rules, and ultimately we believe this would contribute to also a level playing field in the sector. My next point, well, here I have to agree again with Mikko, who I can see has been reading some EDPS papers, opinions and articles, stressing the difference between the fundamental right to data protection and the right to privacy. These are indeed not the same. There is a certain overlap, but it is important that in particular in the context of the e-privacy directive, we do have provisions which go somewhat beyond the protection that could be expected on the strictly speaking data protection grounds, such as those included in the GDPR. Article 5 is a prime example, on the one on confidentiality, but also Article 6 and 9 on traffic and location data. Indeed, the regime which is set currently in the e-privacy directive offers a somewhat higher level of protection to the individual than could be expected on the basis of data protection rules alone. And I don't even want to go into the discussions which still, believe me or not, take place, flare up regularly, whether some specific examples of traffic data actually are personal data. We do have these discussions. We have a preliminary reference pending to the Court of Justice, so this is still one question, but another is the available legal basis for processing. So in data protection laws, normally you have several different bases for processing, while in specific cases such as here, there is a clear requirement to obtain prior consent. And this is one of the expressions of a higher level of protection. Well, since we are speaking about Article 5, as already mentioned earlier, Article 5.3 is much more than just the cookies provision. We can discuss at length about its effectiveness, the need to strengthen or relax those rules with respect to specific examples, such as first-party analytics or cross-device tracking. But it is important that this is the main provision that protects computers and smartphones against hacking, tampering for interception purposes, malware, spyware, etc. We do not exclude that some of the provisions of the current directive, some of the principles established that there could be adequately covered by other instruments or by the new forthcoming GDPR data protection rules, but we have not yet completed our analysis, so I will not go into the details now. I would like to also raise one point which was hinted at by Rosa. One of the consequences of the fact that the e-privacy directive currently, as I mentioned, sits somewhat between the telecoms framework, the framework directive, and the data protection directive, is also that in some countries it's the data protection supervisory authorities that are in charge of enforcement, and others it's the telecom regulators. Experience seems to suggest that this is not an ideal situation for many reasons, and from our side we would expect this also to be addressed and sorted in the forthcoming review. So to sum up, the forthcoming review is an excellent opportunity. It should be used to establish a clear legal framework that will safeguard the fundamental principle of confidentiality of communications for all users, applicable to all services, because this protection should not depend on the type of service that a user is using without even being aware of the legalistic distinction behind that. More legal certainty should be delivered by means of a harmonizing regulation which will provide at least the same standards of protection as guaranteed under the current directive. Thank you very much.
Thank you. Good morning, everyone, and welcome to this panel. Thank you, Cornelia, for inviting me to this panel. I have to be honest with you that I was a bit puzzled with the topic of this panel at first, not just because I'm lacking technical knowledge, I have to say, on the e-privacy directive, but thanks to my colleagues, for example, who clarified, for example, abbreviations such as OTTs, which I'm totally unfamiliar with. I was also puzzled with the topic of this panel, since we're speaking of a review exercise. And of course, we all knew that this was coming, the review of the e-privacy directive, after the big reform of the GDPR and the law enforcement directive. But speaking of a review makes me uncomfortable in two ways. And first of all, because we're speaking of a legal instrument where studies have shown that the level of harmonization is not that high. Studies have shown that in different member states, of course it's a directive, I know that, that interpretation of confidentiality, dealing with traffic data and content data is still quite different in different member states. So that makes me a little bit uncomfortable that we're reviewing this instrument without going into this topic of diversity and the level of harmonization. On the other hand, when I hear that a review may go hand in hand with an expansion of the scope, considering the fact that there are law enforcement exceptions here, that also makes me a little bit, maybe not uncomfortable, but I would want to warn for being careful here. If we want to expand the e-privacy directive to, and now I have this new abbreviation in my head, of course, to OTTs, which I've understood include services such as Skype and WhatsApp, which you've all used. What are law enforcement exceptions to these? What I mean by that is you as a user of these services should be aware and should be able to find in your national legislation under which conditions and in which situations law enforcement, police authorities, may have access to your private communications over these networks. This is what I mean by law enforcement exceptions. So if the e-privacy directive is indeed expanded with these OTTs, then that law enforcement exception comes with it. And then I have a few other questions. And this is why this panel is so interesting, because we're actually at the start of the discussions, as pointed out by Rosa at the beginning. We're at the start of consultation and the start of the reviewing exercise. So in fact, we could possibly conclude in half an hour by saying there's still more questions than answers. And I'm sure that's also the case for the law enforcement exceptions. If we speak of law enforcement exceptions, we have to keep this in mind. We're speaking here of situations in which information could be withdrawn, could be gathered from private communications in one country and could be used in a criminal file, in criminal proceedings in the other country. This triggers a few other questions. First of all, we have criminal justice systems in 28 member states, and between those 28 member states there are small to large differences in criminal justice systems. We're speaking of limited EU competence in this field. Why? Because criminal procedure in itself, criminal law as well, but specifically criminal procedure aspect of criminal law is a part of law that is very closely, inherently connected with the identity of a member state, of a country. With identity, by that I mean with the cultural identity, with the historical identity, with the political identity, to a certain extent, religious identity of a country. Meaning that in this aspect, in this specific branch of law, member states are not willing to give up all competence to a supranational level. Hence, the EU's limited competence in this field. So when we're speaking of investigative measures of interception of wiretap, member states still regulate this in national legislation, and national legislation will differ from country to country. But when we have cross-border exchange of information and of evidence, we go from one system to another system. We gather information in system A and we use it in the criminal proceedings in system B. And that triggers questions on the admissibility of evidence, also something that is a national competence, not an EU competence. Information that could be gathered in system A and is admissible in system A, but will not be able to be used and so will be inadmissible in system B, cannot be included in the criminal file as evidence. So you have a waste of time, a waste of human resources, a waste of financial resources, if this information comes back to the criminal proceedings and cannot be used because of, for example, an infringement of privacy rights. So a long explanation to point out the fact that these questions have to be dealt with as well. This is not just about OTTs, this is not just about confidentiality, this is not just about e-privacy, this is also about the exceptions for law enforcement. So I support this review on the one hand. On the other hand, I do want to warn, and that will be my concluding remark now, because I'm sure that there will be many questions from the audience and we want to make time for that too. As a concluding remark, I would say widening the scope of the e-privacy directive, yes, but please be careful with the law enforcement exceptions and also think of admissibility of evidence, mutual legal assistance, and cross-border exchange of info. Thank you.
Thank you. Amidst this rain of Twitters, it is a pleasure to have this serenity on this panel. I enjoyed both, by the way. But this is where we are. There is an upcoming reform. There are privacy aspects to it, civil liberty aspects to it, but we also hear that the focus is on regulatory aspects, streamlining and so on, lawyer stuff. And so that is as important. Cutting red tape is important. And I'm very happy with the agenda that the Commission presented us. And I think if CPDP has a role, then it's to think ahead what should be on that agenda. So that's where we do some crowd sourcing. We're gonna collect the questions. I saw many of you listening very attentively, half of them being involved themselves in this area. So my question to you is, shoot your remarks and questions, and we will be happy to answer them all. Go ahead. Who has a question?
Do we get to react to the other panel?
I think that's a better idea. Wait a second with the question. Think about your questions. Anna wants to react, and that's good.
Thank you, because I was far too quick to say that we won't have an adversarial panel today. No, just a very quick reaction to what you've just said, Els. Obviously, the fact that the specific exceptions which are included in the e-privacy directive only apply within its scope does not prevent member states from enacting legislation which goes far, much further. So, and we have seen it, for instance, in the UK Act on Data Retention. I mean, there were several of them. The RIPA, the stopgap, currently in force, but also the new proposals in other member states as well. The national data retention rules, interception rules go way beyond the e-privacy directive. They don't use this as a legal basis to have this possibility. What the e-privacy directive, however, the applicability of the directive does is to bring those national rules within the scope of application of EU law. And this is when the European Charter of Fundamental Rights becomes applicable. And this also gives jurisdiction to the Court of Justice. This is, among other things, why the Data Retention Directive was invalidated. So I would respectfully disagree that there are only possible disadvantages to enlarging the scope. One way of looking at that would be to bring a broader range of national law enforcement access / interception measures within the remit of EU law, and hence the jurisdiction of the Court of Justice and the applicability of the Charter. I will not comment on the other points you raised, because personally I think that they go really way beyond the legal basis which the Commission has to address the review, but maybe that's something for Rosa to comment if she wants. Thank you.
Maybe just on the same vein as Anna, I also think that the member states, as she said, currently already go beyond imposing obligations on retention or interception on telcos and OTTs, and the legal basis currently now is for telcos Article 15 of the e-privacy directive, for OTTs or other Article 13 of the Data Protection Directive, ultimately linked to the Charter. And when you look at the requirements, they are the same. It has to be necessary, it has to be proportionate, it has to be based on law. So the legal basis exists beyond the scope. I don't see this correlation as neatly as you see it.
Just a short reflection on the points. So the e-privacy directive rules that we most often talk about are the rules that apply to, let's say, private sector use of this data. But I think it is a really important point when we review these rules and think about the principles that should apply, that we don't forget the aspect of law enforcement access or lawful interception in these topics. It's important because of the fundamental rights issues that are associated with it, and because of the practical operational issues that it will have an impact on. So the future of communication services is perhaps more characterized by not being so much bound in, technically or architecturally into one particular country. Communications will be delivered over networks that physically reside in certain countries, but the over-the-top services there's no necessary link to a physical or location or particular country. So the rules and obligations that relate to providing law enforcement access to communications data that today are dealt with on a national level will add a layer of complexity that the Commission will need to very carefully consider in order to make sure that we don't create a very difficult operational and practical and a legal problem.
Just a very brief rebuttal from me. Thank you for your comments on my points. My point was not to say that there are only disadvantages. Basically, my plea was based on a request to please do not forget the law enforcement aspect, because it's very often overlooked in these types of reviews and in these types of discussions. Thank you.
We'll add it to the list.
Yes, let's look at law enforcement and governments, and that I say to the tweets. So please, dear audience, help us. Let us make this agenda for the e-privacy reform, and share your thoughts with us. Who has a question, please? Yes, I see a question there, a question there. We're going to collect 2-3 questions and divide them fairly, so if you all want Rosa's attention, you won't get it. We don't do that. We brook them. We are brokers. Yes.
Hi, good morning. Frederik Borgesius of the University of Amsterdam. I was wondering whether you could comment on the idea of just applying all the provisions in the e-privacy directive on information society services like are defined in other directives. Then we don't have to think much more about exact scope, etc. We just arrange it in one go. But there are probably disadvantages that I don't think of now. Thank you.
Was a question? Over there, yes, please. Yes.
Hi, my name is Simon Hania. I work for a European technology company known as TomTom. And we specialize, as we like to see it, in freedom of movement. And what we see happening is that we use these communication technologies not necessarily to inform people or might make people communicate, but to allow them freedom of movement. So it's about movement. One of the things to take in consideration is, of course, the law enforcement aspect of all of this, but also the fact that we're talking about networks. But the technology advance that we're doing, and this is a project also stimulated by DG Move, so not DG Just or DG Connect, but DG Move, which is about devices communicating directly to amongst each other. So your car communicating directly to other cars. No network involved anymore, yet communication. So I would like to ask the panel to reflect on a future in which we will have direct communication between devices worn by users or in which users are sitting. How would that affect the principles, if they exist at all, of the e-privacy directive going forward?
All right, 2 beautiful questions. Mikko, you want to address the second one first?
Yeah, that's an interesting problem. So what should the rules be for regulating communications that take place directly between devices? Of course, that sounds a bit like old-fashioned walkie-talkie scenario, I guess. So for me, the confidentiality of communications then raises the question of what is communications? And what is the type of communications that does require protections? And to me, it's the origin of the rules that relate to protection of confidentiality of communications is that there are messages being handed over, metaphorically speaking, to someone who delivers the message. It's like a post office kind of to someone else. So the parties of the communication, in a way, rely and trust that the middleman acts responsibly. Of course, in a connected world, there are many of the middlemen quite often. But so that seems to be the rule, so that the post office doesn't sell your letters, would have been a traditional case, or open them and start making use of your messages. And in electronic communications, it's broadly the same. approach. So if there is no middleman, then we have to ask ourselves that what is the harm that we want to protect the users against, and if we cannot find the harm, then we probably shouldn't regulate.
Anna has a reaction.
Yeah, no. I fully agree that I think still the reference to communications is key. I would be speaking personally, somewhat skeptical to just saying, okay, we replace one concept by another one which has been defined also many years ago for different purposes in a different context. And we have a few of those buzzwords available, but I would rather maybe focus on, again, on the principles, on the fundamentals. What is it that we want to protect? And again, I'm coming back to the same theme. The current directive relies on definitions which are set in the framework directive, which have been also, again, created a long time ago for slightly different purposes of liberalization of traditional telecommunications market, and just were taken over as a legacy in this instrument. I would agree that it's, well, I said before, this is no longer really fit for purpose, but we should focus on those elements of communications confidentiality that we want to protect. And I don't know how many of you are aware, I know Frederic is, there is a recital in the e-privacy directive number 16 which tries to give examples of what is or what is not communication that merits protection. So, for instance, it says information that is part of a broadcasting service does not constitute a communication to unlimited audience, does not constitute a communication in the sense of this directive. However, in cases where the individual receiving information can be identified, for example, with video on demand services, the information conveyed is covered within the meaning of communication. So we can see that already in the past there were attempts to like crystallize what is the key and try to start defining the scope from there. And I would personally think that that's the most promising approach. Thank you.
Yeah. Okay. Nice. Just to perhaps to go back to the question that Frederic Borgesius asked, whether we could include all information society services. Obviously, I'd like to hear more about the idea, but the e-privacy directive is about communications. Information society services cover a range of services that go from the Carrefour online selling products and services, whereas here we are trying to focus on communication providers. So to the extent that an information society services provides a communication tool, then yes, absolutely, I would see that as a part of this exercise. We call them OTTs, but I think we could call them information society services providing communication services, to clarify.
Just a small addendum. So one of the fundamental problems with the current definitions, as Anna also brought up, is that the definition of the applicability is determined by whether or not the service consists wholly or mainly of communications, and we know that now actually communications takes place in context where it is perhaps a meaningful part of, but not wholly or mainly of an information society services. So I personally think that idea is something that is worth exploring, how to adjust the definitions to make sure that where the communications is a meaningful part of the service, then it is captured by these rules.
Yeah. Before I take some more questions, just want to abuse my role here. I think having regulatory diversity and pluralism has this old constitutional advantage that there are more people that check and balance each other. So I applaud a system where several DGs have their toy and defend it well and don't give in to a mastermind that streamlines everything, because there might be interesting checks and balances that we lose then. So I'm fully against mainstreaming legislation to an extent that it is oversight is possible. I like the diversity, and that's why I like living in Europe, by the way. So, but that was questions, ladies and gentlemen, questions. Frederick, are you happy? Others, I see the people from CDT listening very carefully, so I think they have many questions. Go ahead, use the floor for your own agenda, your own questions. We still have some time. I'm not a believer in filling panels. Yeah, there's one. No. All right, question in the back.
TJ McIntyre from Digital Rights Ireland. I missed the very start of the panel, so apologies if you've already covered this, but I was wondering to what extent the panel believes that the review of the directive should also extend to stored communications also, which in many ways are more sensitive, more pervasive, give a much bigger picture of a person's overall life than ongoing current communications. It appears, certainly in some jurisdictions at the moment, that access to stored communications is placed on a much lower footing and in some cases can be seized without necessarily any judicial oversight at all or any independent oversight at all.
Could you please repeat the latter part of your question? It was very difficult to understand.
I'm sorry, is this better?
That's much better.
So my question is in relation to stored communications. To what extent is it currently the case that we have an overview of policies within member states on access to stored communications? To what extent is it the view of the panel that existing controls on access to stored communications are adequate? To what extent should a review focus not just on access to real-time communications, but on a person's overall communications history? It strikes me there's a discontinuity here. We have, in the challenge to the Data Retention Directive, a very clear judicial statement that access to communications history per se is of great concern, but we don't necessarily have similar access and controls to the contents of a person's communication history.
We need a team building moment here. Yes, Mikko.
Well, I may at least elaborate on that, if not answer. If I understand your question correctly, the communications could be stored, for example, on your PC, you know, in the file system there, or it could be stored at the the provider of the communications. And I think that's a really interesting question. I have once been involved in it's a criminal investigation where the question of the stages of whether or not the emails stored on the PC of the individuals were considered electronic documents or were they communications, and this took place in Finland many years ago. And according to that legal system, then they were considered electronic documentations, and no warrant was needed to confiscate them. That's could be very different in some different jurisdictions. An example of what else was also highlighting that the legal systems are very different. I think if you have if the communication service provider is retaining messages on behalf of the user on the service, it may be a question of who's the controller and who's the processor, at least. Most likely at least one answer could be that the provider is processing that data on behalf of the individual and therefore is bound to what they have agreed. We also know that the Data Retention Directive that was repealed and then introduced in many countries through national legislation set some boundaries on how the retained information may be used. I think, yeah, so broadly speaking, I think personally that these stored messages do require a level of protection, but how it's then fit to various legal systems is beyond this panel, I guess.
I wonder to what extent this is a question beyond this panel, but also beyond the available legal basis of what the Commission could be trying to do under this directive. But I agree that this is a very valid point. And actually, in the early morning panel on crypto wars, that was one of the points that were made. That, you know, nowadays, since I think iOS 8, the iPhone is encrypted with the users holding the key. But most of the users are still automatically backing their data up in the cloud, in the iCloud, where the agencies can get a warrant or access it without a warrant. So my guess, I'm not an expert, but my guess is that this is a very open question in many legal systems as well.
So I take this as a very useful suggestion to put that on the agenda and to have a look at the aspect of storage in this reform process. We have time for more questions, so or remarks, or personal, poetical insights. And if not, I'm going to close this session with, if the panel agrees. I think we launched the issue, we set it on the agenda. I'm very satisfied, and I thank the members of the panel, Cornelia for organizing it, and you for listening very attentively. This is sensible up to here. Thank you.